Okay. Good morning. You're Carlos Rodriguez.
Yes.
And so Mr. Salinas
Yes.
has been here before, and we went through some motions, and I granted, I guess, an order uh, for the investigator for Mr. Salinas and the investigator for the Assistant District Attorney's Office to get together at an appropriate time for that investigator to uh, walk through, take pictures if necessary, not touch anything in that home. Is that why we're here today?
Yes, Your Honor. It has not been done as of today. Sent multiple follow-up emails to Coley. I understand that new district attorney.
Yes, Ms. French is new on this, so I'm
Yes.
sure she's got up to speed. Good morning and welcome.
Good morning, Judge. Thank you.
Yes, Your Honor. But I mean, we've, I've made all good faith efforts. I've put the state in contact with my investigator. I've made diligent follow-ups throughout the last month. It seems that the order has not been carried out.
And Mr. Gertz, why are you here standing up?
With Lori on Solar Gomez, the home who's the homeowner,
Okay.
whose home is set to be searched, and I'm here to start enforcing rights of that home search valid.
Well, it's not a search. I'm not allowing anyone to search anything. It's just a walkthrough to get the kind of the lay of the land of the house, is my understanding. So I think there is a distinction with regard to that. And go ahead.
But I'm enforcement, there's no case law in such an exception for law enforcement or anybody walk through a home and start photographing. And I absolutely object. This this person has a Fourth Amendment right free from searches, and entering a home is a threshold search. And this court has ruled on that in lots of occasions. There's not some imminent threat, there's not some safety suite. This is a fishing expedition for evidence and attorneys. And we're asking the government and another parties or a party to a case, client's not a party to this, lawyers to give a generous home without his permission. And your order specifically says he's got a right to assert his Fourth Amendment rights. I'm here asserting his Fourth Amendment rights.
Your Honor, if I may, Fourth Amendment protection of unreasonable searches. Given the fact that there might be potential Brady evidence again, my client is facing potentially up to 40 years in prison. So I think, well, of course, Mr. Loran, who does have Fourth Amendment right, I'm not arguing that he doesn't. That's clearly balanced here. And I'm not the state of Texas, so I wouldn't be able to press charges or anything is found.
Request search warrant.
Yes.
Your Honor, may the state be heard on this matter? First, let me say that I suggest, while you've been here, placed my hands on this file. This order came to my attention yesterday when an email was forwarded to me. And so I backtracked a bit, find out how this all occurred. And my initial concern is that the way the order is written, it does seem tantamount to a search warrant. And our CCP 106 says that no person shall be deprived of their right to remain free from seizure of their persons in their houses, their papers and possessions from unreasonable seizures or searches. Not only was the state not given notice of the motion that was provided to the court in order to have an opportunity to have notice of what was being required or an opportunity to respond in writing.
Well, I think they were. I mean, we were here on this motion previously.
Yeah,
It went.
Colby argued.
Yeah, there
Very
was an
much
argument.
the same arguments that they're both making, both attorneys are making,
So
are made back then.
let's everybody stop.
Yes, sir.
Here's what we're gonna do. I'm going to hold the enforcement of the order at this time. I'm going to do some of my own research based on the objections that have now been lodged by the assistant district attorney as well as Mr. Gertz on behalf of the homeowner. What I would like is for everyone to do a short brief on the matter, and get that to me within a week or so, and then I will make some type of ruling and we can come back and at that point, Mr. Gertz.
Chair, can I make a proposal as sort of often, things with life, I could have to reinvestigate, who's a former Texas Ranger, go and photograph each room in the home. And that is expense, probably cost $300 total or something, but, photograph each room in the home. And come back, get an affidavit saying these are true and accurate photographs, and we can do it as a business records affidavit, so it'd be admissible at trial. And that way, there's no state incursion into my client's home, and there's no other incursion into my client's home. And yet, it's a trustworthy source, you know who I'm talking about, and my investigator can come and give us one statement or whatever, proving up the photographs as well.
Your Honor, it seems like we're just, the purpose of that would only be to delay. My initial,
Why,
my initial motion, Your Honor, was just my investigator, not at the defense's own expense. I didn't ask for the state's investigator, that was something compromised.
that's what I ordered so that the homeowner would have
Right.
that level of
Right.
comfort, which is one of the things that Mr. Hopper, but
Right.
why?
I don't oppose. Yeah. Sorry, Your Honor.
If what you're going in for, which I said is not a search and not
The Fourth Amendment protects against unreasonable searches, but trial preparation often requires documentation of physical spaces. The court chose compromise over confrontation.
inspect layout of the home, then why would there be any issue with allowing Officer Best to go in and take pictures, even potentially a video just of the lay of it, so that there would be, I would ask if he did that, pictures and a video. He could come in, swear, and then that would be the same thing that I was going to allow y'all to do. And that way there's not your people going in. If he's willing to offer that, I think that probably sounds like a good compromise.
Well, look, Your Honor, I don't, uh, and I appreciate the counsel's suggestion. My only thing is, because we live in a world full of human beings. I'm not saying that I don't trust whoever their investigator is. It's just I don't see what the issue be with allowing my
Fourth Amendment. But
Sure, Your Honor.
so if we're going to avoid a Fourth Amendment issue and me getting mandamus or whatever could potentially happen if I force this issue and there's an easy way around it where I'm potentially not going to get in legal trouble, then I like that idea. And so
I'm not trying to get you in legal trouble.
so what I'm going to do at this time is I'm going to modify the order that I previously entered, and I'm going to take Mr. Gertz up on his, if you're willing, obviously, if you were going to pay your investigator to pay, I'll let y'all get together with the investigator who is a very trustworthy person, who's a former ranger. He comes in and does stuff all the time. Different attorneys on both sides of the table here in Jefferson County. So if you guys can get that taken care of, I'll let y'all visit, get that done. I want video, thorough video, so that somebody would know exactly how to potentially lay out a house, pictures of the rooms, every room, and a thorough video of the house. If you guys are willing to do that, then I will modify the order that is what's going to take place and get that done within, I would say, 2 weeks. Okay?
Your Honor, I would concede to allowing, that ranger, but I would ask for a specific deadline within a week this year. That has been.
Well, I just said 2 weeks, so we're gonna get it done within 2 weeks. It's already Tuesday.
Can we have it the 24th, just so I have if there's any concrete date?
I'll give you that.
Thank you.
So we're on the 10th.
Yes, ma'am.
Let's get it done by Friday the 20th. Mr. Gertz, Friday the 20th, that's the rest of this week and then all of next week. If you'll get that done and that information, and what I would ask is if you would make that available to both Mr. Salinas as well as the Assistant District Attorney. That way they both have the information so that if he's talking about something, she also has a copy of it. That would be great. All right. So I'll make some notes. So what I'm going to do, I'm going to make some notes. Do you have my signed copy? Give me that one. Yeah, that would be better. So what I'm going to do is make some modifications on that order, date it today, with what that order is that I just did, and I think that avoids all of those issues.
Yeah, if I
Yes,
may,
ma'am.
I think it might be prudent to also order that there be no alterations to the home of Mr. Dart's client prior to
As of right now.
this being affected.
Sure. So I would ask Mr. I'll make that a part of the order. And here's the thing, I don't think I can really order them to do anything. They're not a party to this thing. And so I would ask that you please have your client cooperate, with not making any changes of substantive. Obviously, they're gonna live in the house, but, with no major changes before that's taken care of. If they would, go along with that, that would be great, but I don't know that I really could order them to do so, but. I will make these modifications and then we'll reset it. Probably what I'll do is about a 45-day reset instead of a 30. That gives you the time to get that information back and then to kind of all get on the same page and we'll see where we are.
Thank you, Your Honor.
Okay, thank you. Thank you, Mr. Church. Thank you, Mr. Salinas. Good morning. Are you Luther Sharp?
Yes, ma'am.
And Mr. Sharp was previously in court in cause number 25 DCCR 0916. Entered a plea of guilty to aggravated assault with a deadly weapon. The agreement was for a cap of 15 years in prison and a dismissal in cause number 25 DCCR 0917. I've received a pre-sentence report and have you both had an opportunity to review that report?
Yes, Your Honor.
Yeah, sure.
Are there any additions or corrections to the pre-sentence report?
No, Your Honor, I would note for the court, we did receive a follow-up memorandum, after the PSI was, ended. The, probation department was able to get in touch with the complainant in this case and they echoed their agreement with 15 years.
Okay. I don't see that I have that. Have you had an opportunity to review that?
I don't think I got that.
I would see it on the email.
From probation?
Yes, sir.
Luther Sharp. But it's stating that the family
Got the
is.
victim of the
the victim
shooting,
is-
urged for full 15 years, Your Honor.
Okay.
Yeah.
All right. I also have received numerous letters that Mr. Vasquez has provided on behalf of Mr. Sharp, Mr. Nichols. Were you given a copy of those?
I was, Your Honor.
And then, in addition, there are jail incident reports. We've talked about those in the past, and I have any updated ones if y'all had an opportunity to review that as well.
I have, Your Honor.
Yeah, sure.
Okay, then, Mr. Vasquez, you may proceed.
Judge, the only typo on the first page under defendant's version, first sentence, first line. Then it says, I got 2 bites I got out of Louisiana. I'm sure the court could put that out of context.
Okay, they weren't trikes, they were bikes. I mean, there's such a thing. I think there's,
Right.
they were trikes.
Yes, ma'am.
I don't know what tracks are.
The real bike.
Well, then I withdraw my,
Thank you.
I beg your pardon. I should have known Justin doesn't make any mistakes. Judge, I know the court said you have all the support letters. I would just, urge the board to sentence Mr. Sharp to something less than the 15-year cap.
Do you have a copy of this? Can you find him one? Give me just a second. I'm reviewing that dated, the memo. I want to make sure I've read that since it has, interested party statement. I'll give you a copy to Mr. Vasquez.
Thank you.
In sentencing, the focus shifted from constitutional theory to accountability. The victim urged the maximum under the plea cap. The court weighed history, conduct, and public safety before moving forward.